second degree,
Yes, sir.
and then a third degree enhanced to another second degree. So he's looking at a total of 44 years in all of these, correct?
Yes, sir.
All right. And what we'll do is we'll try these non-state jails first, okay?
Yes, sir.
We got a third degree felony, illegal possession of controlled substance with an aggravated assault prior conviction, and then we've got an issue. And then a criminal mischief third degree felony, and that alleges an aggravated robbery final conviction. That can't be right because it's the same cause number as this aggravated assault. We got a problem between 2028 and 968 in the allegation of those prior conviction. It's the same date, but one states aggravated assault with cause number 74205. The other says aggravated robbery 74205. That can't be.
Aggravated robbery, we can correct offense.
Y'all got to correct that, right?
Yes, sir.
Okay. With that, so what we'll do is which one do you want to try first? I'll let the state make the choice. They're the ones that bought it out of those two.
My thought was the possession, judge, but that's the one that I've got to correct the indictment on, so I may be able to do the criminal mischief instead.
That's just a fair allegation.
Yeah.
Sufficient just
Yeah, I mean, that can be,
That's true.
it's,
So I would probably try the possession first, judge.
all right, that 23 CR 2028 will be set first.
Thank you.
And then we'll just try the next one after that. And as you know, if you're not eligible for probation if this is true. So we'll go one, then we'll go the other, and those cases, of course, if they're sentences can be stacked on top of each other.
I think he would be eligible for probation from the court, not the jury, since they're not 3G offenses, but.
Yeah, I know, but he's asking for a jury trial.
Right, but the jury
Oh, okay.
isn't necessarily, the court could still get probation. I think he's eligible for probation from the court, not the jury.
Oh, you're saying, well,
Whether he get it or not is another question, but I think he's eligible for probation.
if he's not eligible in front of a jury with a prior conviction.
But it's not a 3G offense.
No. No, so it's
Unlikely.
It's-
he could.
it's a and it can be brought up, of course, if he testifies. So it's got ramifications that aren't in the best interest of the defendant. That's why I always urge people, don't commit a crime after you've been previously convicted, because that past is never really in the past, like the great author once said. What's in the past is never really in the past. It comes back. All right, that's what we're gonna do.
Would the court consider bond reduction, John?
No. Yeah, well, I'll consider it. What do you want to say about them? Their bonds are how much right now in those?
You said a no bond, judge, because he was having drug patch issues is what my memory is on this. And then when he failed to show for court on September 30th, it was an additional claim that he had been hospitalized, and there was a warrant outstanding at that time for a new offense, which turned out to be 25 DCCR 0968. You said no bond until he's brought into custody.
We could just request a bond.
And I'm looking at criminal history of public safety report in the defendant, Justin Kyle Moore, date of birth March 19th, 1978. You got according to, among other things, let's see, the conviction of unlawfully carrying a weapon, and that's a misdemeanor. That was in 1995. But we do know that The indictments in 2028 and 968 allege in those second paragraphs of the methamphetamine possession charge in 2028 and the criminal mischief charge in 968, which are both third-degree felonies, that it's alleged that you committed the offense of aggravated something.
It's aggravated robbery, Judge.
It's aggravated robbery. Yes, it incorrectly states aggravated assault. But it's aggravated robbery in 968 as the second paragraph. And the 2028 allegation of aggravated assault states on that same date, May 19th, 97, in that cause number in this criminal district court that you committed aggravated assault. So we've got a problem. The state contends it was aggravated robbery, and then they are led, they can correct this, but you have a prior conviction of a violent crime. You got 4 new felony offenses.
One of which occurred while he was out on bond, Judge.
Election.
And so what's his bond, did you say now?
I think it was a no bond, John.
It's correct, no bond.
So you're asking for, Rife, how much?
$20,000.
I'm sorry,
40,000,
40,
20.
20 on which ones?
Whichever ones is no bond on.
Okay, there's only, are all of them no bonds?
What are your bonds, Mr. Morgan?
Hold on, we'll find out.
34,000, I don't know
The cases?
the,
Yeah.
Showing. This is a mess. You got 4 fires to find. They're all felonies. And this says you're not eligible. You've been convicted, so you're not eligible for probation in front of a jury, and that's going to be problematic.
For your education, you received a 20-year sentence on that prior offense.
Is that correct?
What was the date of that? Did they say?
97, I got the conviction. May 97, I believe.
Date of judgment is June 26, 1997, Judge. The date of the sentence was actually May 19th, 97.
97.
Subsequent to that, he also received a state jail felony conviction for possession of controlled substance. That was in 22. So I don't agree with the $20,000 request. It just is not commensurate with his record and his history. And in addition to the fact that these accusations from the last felony comes up while he's out on bond.
Those bonds are on 1784, it's $5,000. On 2027, $7,000. On 2028, it's $15,000. 0968, there's a no bond set.
Yeah, this last one, the third degree criminal mischief with the enhancement was allegedly committed on or about April 15th, 2025, which was after the defendant had been arrested and posted a bond in 2023 on the illegal possession of a controlled substance. So he commits this newer offense after he had posted a bond on this case. He's charged with committing an offense after he was placed on a bond on the 2028. So that's a tough thing.
It's probably,
It's problematic to say the least. So he's got he does not have bonds on these two.
that's just one case.
Just the one apparently.
On the 098, is in no bond.
Is that correct?
Okay.
That's the criminal.
Then, that bond will be set at 150,000, and plus he has to have a GPS device if he posts the bond. Well, we're talking about
Yeah.
violent crimes
Again, Your Honor, I understand the court's.
and a criminal history
But-
and a circumstance of you're on bond, they're serious, and
But
then you've got 4 pending cases with a violent criminal history, and shouldn't be using drugs, shouldn't be committing any kind of felonies, and those all count against you, and life adds up. Each chapter in the book is important in the book of life. That's the ruling of the court.
Your
We'll
Honor,
set those for trial, right? That's what you want.
yes, Your Honor, obviously, I understand the court's concern with community safety in the situation with the defendant's criminal history and the circumstance that he is alleged to have committed this offense while in bond for another felony offense. But obviously, there's a context to this as well, is that, with a trial setting, it's literally years before the case would get reached for trial. And it's getting to a system of administrative detention
Well,
because of the length of the.
Here's what's interesting is
If the court would consider a transferring to drug court.
what's interesting is now that you bring that up, is no court is off. What the Constitution talks about is right to a trial by jury, which this court pledged I would do. And we're at 610 felony jury trials, which has not been reached by anyone apparently before. We are setting new ground in the world on it in this country. Now, I'm sure maybe there might have been, but it's never been recorded. Point is we try cases here. The problems in what is pending are people who are waiting trial, and if they're in custody, and most are not. Most have posted bond and are waiting and wait and wait and wait and wait. I wish I could clone me, but I can only try one at a time. And I take up these cases where I'm looking at 4 new cases. 2 of those are enhanced serious felony offenses. 1 committed after he had posted a bond. I'm not apologizing. The court's rulings are what they are.
It's the right to a speedy trial, but be that as it may, Mr.
It's important to
Mr.
me.
Ham indicated that he was wanting to try the drug case first. I would just request that since neither of these cases involve a violent crime, that the court consider transferring it to drug court for a speedier disposition
Denied.
trial.
I hope since 1/3 of our caseload are drug cases, I'm hoping he stays busy, and he's busy as we are.
The
But
delay for trial is much less than.
I understand.
So many of the cases are resolved proportionally more than this court because of the less serious nature of the offense.
we're gonna work as hard as we can to get to him, and hopefully this whole thing is wearing down slowly. There's less cases, but there's still no end in sight to the new cases being filed. I mean, I can only try 1 a week. And everybody knows we try more than everybody else. Nobody has tried cases like we have. So that's all we can do. That's all we can do. Thank you.